that we look for a long-term solution and not a temporary measure. Thank you, Mr Speaker.
Simon Bridges.
Speaker, I have listened very carefully to the debate and take seriously the concerns that I've heard from Naima Huta, from Rodney Hyde, from Keith Locke, from Shane Jones. Police shouldn't be able to do as they like. They should be beholden to high standards. But as I read this bill, it is a fair and a modest bill. And Defence Counsel in this country will be free to pursue any pre-trial argument that they like, to take the police on in terms of irregularities, illegalities, improprieties, to attempt to have evidence thrown out, and if they are successful and significant enough evidence is thrown out, to have the charges dismissed. As I say again, this is, in my view, a modest bill. It does one thing. It says that covert video surveillance is not unlawful in and of itself. Trespass, bad faith, trickery, irregularities of any kind, and people through their lawyers or indeed in person will be able to make applications to the court. But video surveillance in and of itself is not the problem. And given what I've heard from other members, that indeed they don't believe that covert video surveillance in and of itself should be a problem, that it should be permissible in this country, I suggest many should be supporting this bill when it comes back to this Parliament. I want to very briefly give a practitioner's viewpoint, having argued many cases, in many cases, about the admissibility of evidence, and to say that, frankly, from my view and from other practitioners I have talked to's view, the Supreme Court's decision has changed the commonly understood position in regard to covert video surveillance in this country. I mean, absolutely no criticism whatsoever of the Supreme Court and their decision. But as a practitioner and talking to very experienced practitioners, there is some confusion about whether the decision, or decisions I should say properly, because there are a number from the Supreme Court, from differing judges, is restrictive, and that all it is saying is that where there is a trespassatory covert video surveillance, then that is out, and the evidence there is out, or whether it is much more expansive, as perhaps some of the comments from the Chief Justice would indicate, that always covert video surveillance is out. And that confusion from very experienced practitioners in this country is reason enough why quick clarification of this legislation is required, so that we know, so that practitioners know, so that accused know that covert video surveillance in and of itself will not be illegal. And I say to this House, in fact, Supreme Court cases, and this case, and this bill before the House, need to be put into a proper context, I should say. Covert video surveillance has long been a critical tool for law enforcement agencies, particularly regarding serious drug cases. There's no question in Auckland, and probably in the rest of the country, but certainly in Auckland, that enforcement agencies will have been using covert video surveillance in ongoing criminal investigations, and that prosecutors will be relying on it in current large-scale commercial drug cases, cannabis, methamphetamine. And I say to this House, and I don't say it in an overly emotional way, but the kind of havoc that large-scale methamphetamine operations wreak in this country in terms of potential dangers to those involved, explosions to the police, to the people who have to go in, but also the misery that they peddle on our streets should be taken into account when we consider this issue, because it is those sort of cases that are predominantly the cases we are concerned with when we talk about covert video surveillance and its day-to-day use in this country. And so in practice, I say it again, counsel and accused will be able to argue evidence in or out on the basis of, as Wayne Matt has said, the Bill of Rights Act, but also Section 30 of the Evidence Act, where judges will be enjoined to balance factors, to take into account what has happened, to get into a quite detailed and unique case-by-case factual analysis of the circumstances before they decide whether evidence is in or out. That's not for us to adjudicate on. The courts can and will do that. But I offer this. It may well be, in cannabis cases, a 7-year maximum term of imprisonment in all cannabis offending, the most serious, that where there is covert video surveillance, where it's by trespass, it may be that that evidence ultimately is held to be inadmissible by a court. It may also be in the more serious cases, methamphetamine cases, large-scale commercial ones where, as I say, the maximum term of imprisonment is life imprisonment, that on that sort of a scenario, when considering the Bill of Rights and Section 30 and weighing all matters, that the evidence may well, in the public interest, stay in. As I say, those are matters for judges, but this is a modest and a fair bill that simply says one thing, that in and of itself, covert video surveillance evidence can be admissible.
Members, this debate has concluded. Honi Hauera. Is this a point of order?
No, I'd like to speak to this bill.
Well, I'm sorry, the debate has concluded. All 12 speeches has been taken. This debate has concluded.
Well, I'd like to seek the leave of the House. Could I seek the leave of the House to
Leave
speak on
is
this
sought
issue?
for the member to make a speech. Is there any objection? There is objection. Members, this debate has concluded. The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. The ayes have it. Party votes called for. I ask the clerk for a party vote.
New Zealand National.
57 votes in favour.
New Zealand Labour. 42 votes in favour. Green Party.
10 votes opposed.
Act New Zealand.
5 votes in favour.
Māori Party.
Tuko whae whakahea.
Progressive. 1 vote in favour. United Future.
1 vote in favour.
Mana.
Ko tahi te pōti kore whakai.
Honourable Chris Carter.
1 opposed.
Members, the ayes are 106, the noes are 15. The motion is agreed to.
Video Camera Surveillance Temporary Measures Bill. First reading.
The Honourable Christopher Finlayson.
Speaker, I move that the Video Camera Surveillance Temporary Measures Bill be considered by the Justice and Electoral Committee, that the committee report to the House on or before 3 October 2011, and that the committee have authority to meet tomorrow and at any time while the House is sitting, except during oral questions, during any evening on a day on which there has been a sitting of the House, and on a Friday in a week in which there has been a sitting of the House, despite Standing Orders 187 and 191B and C.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. I understand the government wishes to introduce another bill.
Sleepover Wages Settlement Bill. Introduction.